All right. Okay, you can see the full screen now. Does everybody see the screen that's listed? The slide. So let's go ahead and get started. Welcome so much today to our webinar. We are looking forward to having everyone on today, and welcome to the top 5 things you need to know to conduct better eDiscovery. Apologies for my slow start there. We were having some technical difficulties. My name is Kelly Twigger. I am the principal at ESI Attorneys. We are based in Boulder, Colorado, and I typically act as eDiscovery counsel for my clients, whether that means setting up processes and procedures for them or engaging as discovery counsel within litigation. And oftentimes I work directly with Matt Stipich, who is our next presenter, and also Sarah E. Guerra with iPro in setting up processes and procedures for clients, handling data, and generally navigating through the entire eDiscovery process. With that, I'll turn it over to Matt to introduce himself.
Thanks, Kelly. I'm Matt Stipich, General Counsel and President of Professional Services for Digital Intelligence. We're a Milwaukee-based company that with a strong foundation in digital forensics and work in the forensics and eDiscovery space. I work with Kelly quite often with clients, advising them on best practices for handling eDiscovery in cases.
Sorry.
Thanks, Kelly. I am a Senior Vice President of Professional Services and Consulting at iPro. iPro, I think most viewers probably know, iPro provides eDiscovery software to be able to help in any case in different matters, whether small or large. And my main focus is really to help law firms, service providers, government agencies, and even just corporations to understand what tools they should be using and what's the best approach depending on their matters. So we really help through the implementation, putting some best practices in place as they implement the software. And then, of course, what that goes along the way on consulting through the whole eDiscovery process and how to best use techniques to get better results in the matters.
Great, thanks, Sarah E. So as we kind of talk today, you know, everybody who's on with us today understands the challenges that are associated with electronic discovery, and in large part they come because of these obligations that are placed on lawyers, legal professionals, and parties in matters that are associated with ESI, and that is that we have this duty to preserve information that may be responsive and then ultimately to provide it. And the real issue that comes about with that is the cost associated with electronic discovery and the enormous process that is involved. And as we were getting really sitting down and talking about how we wanted to present today to the audience, the reality is that the discovery process has completely changed now that we're dealing with ESI. And the volume of data that exists and the costs associated with that volume are directly proportional. And so today what we want to do is be able to give you some practical tips on how to be able to control both the volume and the cost of ESI to be able to more effectively and efficiently handle your matters. Some of that is through data handling. A lot of that is through better communication and utilization of the resources that you have on your team. So with that being said, one of the things that we want to start with here is a poll question. And I'm going to kick this out to everybody to go ahead and answer. So in general, what are the types of matters that you're handling? Are you handling commercial matters, employment matters, IP or class actions, regulatory investigations, products liability or personal injury, divorce or family matters, or other? If you're handling other and you want to give us a little bit more idea of what you're handling in the comments section, then we can include that as well. Generally, we're seeing that we've got roughly 56% are handling general commercial, IP, or class actions. little bit on employment, regulatory, and products liability, generally speaking. So that's kind of where we are. With that being said, we'll try to gear our comments in that fashion, and we'll kick off kind of our top 5 things with the first one, which is the necessity now of recognizing that ESI can exist in any size case. When we have larger cases, we automatically assume that there's going to be ESI involved, but this is true of any case. Matt, I'm going to kick this one over to you to start off.
Sure, thanks, Kelly. And yeah, this is something that we've been preaching for years. The fact that whenever a case is initiated, we need to consider whether or not there might be electronic information that's involved. And part of the reason is because of the volatility of that information, the fact that it can be changed so easily. We want to see if we can put ourselves into a position to preserve that information as quickly as possible. Email, for example, and probably even more common than email these days, text messages, we're finding to be extremely relevant in not only personal type cases, but in corporate transactions as well, where we'll see that the email correspondence and text messages end up getting pieced together in order to look at intent of the parties. I talk about a couple of cases that we've had, to show you the breadth of types of cases that you can have ESI involved in. I have had a slip and fall case where there was a party that was going to a business owner's location and slipped on the sidewalk. The sidewalk had not been shoveled, and the business owner claimed that he had sent out an email message to that individual giving him warning of the fact that the sidewalk had been shoveled. And so ended up being an issue as to whether or not the message was actually sent. Was it proper notice to give him warning of the conditions of the sidewalk? So like I say, something as easy as a slip and fall can have electronic information that comes into play. Increasingly, certainly social media, we're seeing a lot more come in because that's a method that people are using for communicating, but it's also an area where people are expressing things more in an utterance standpoint as opposed to something that they're trying to document more formally, and that can be really useful in particular types of cases.
I think it's also good to sort of point out that although there may be different sources of ESI, and in the places where you go and look for them, whether it's social media or text messages, there's also other ways to save information even with your own phones. Or there's a lot of people that want to be able to upload things to their personal cloud, or even save some of those messages to different sources. And so I think it's also important to know that in even the smaller cases, there could be ESI in multiple different locations that would really help your case, specifically for the employment-related cases. As Kelly was mentioning, that was one of the main practices that we saw. And the other thing that I would like to point out in here is that not all data is created equal. So in looking at, as you're trying to figure out where ESI is located, it also depends on what type of case do you have? Do you have to involve additional professionals to really help you with that type of data? Is it financial type of documents that you have to look at? And if so, then that source of the data may be a little bit different than your traditional approach of emails, as well as social media.
Yep.
And I'm gonna add a little bit, if I can, for just a second, and that is that, I was a civil litigator for 13 years before my focus became solely on electronic discovery. It sort of morphed over that previous 4 years, where I came into playing with eDiscovery in about 2003, 2004, when it really started to become prominent. And the reality is that what used to happen in civil litigation is, a complaint would hit our desk that we suddenly had to respond to from a defense perspective, or a new case came in the door from a plaintiff's perspective, and you had to kind of work it up. But we didn't think, there wasn't so much strategy around discovery. You sat down and thought about what kind of request for production you wanted to put out, but you weren't thinking about the volume of information you were going to get because we were so used to people having paper folders, file folders full of paper in their desks. And now that there are these huge volumes of email, it really is incumbent upon us, not only from a preservation perspective, but from a discovery strategy perspective. And we're going to talk about that more in a minute, but to start thinking specifically about what ESI would exist and where it exists. And I mean, for the other side, as well as for your own client, just sit down and think about what is out there. What are the sources of ESI that you use as a person every day, not even just as a lawyer or a legal support professional, and then start taking an investigative approach. That's going to be the first way to narrow your cost. We tend to jump a lot to technology, and I really do think that that's only one piece of the puzzle here, that you can use technology to filter down large sources, but your first step is to really think about what's out there and what do you really need. Our second topic is what I just kind of alluded to, which is being strategic about ESI. And in this context, it's really about applying litigation strategy to discovery. I talk a lot about finding the money documents. So oftentimes with clients, I will sit down with them at the outset of discovery and say, if you were standing up at trial right now, making your closing argument, what do you want to say? And the more you can define that, the more you can define your discovery strategy, because you can say, this is ultimately where I want to get to. This is the top of the funnel that's going to get me to the bottom of this point. And that definition is really what we do in litigation all the time. We look at the elements of the theories of liability and we say, where does our client either have the best potential for earning a big payout here, or where does our client have the most liability? And looking at those particular elements as they relate to discovery is really a key to focusing in your strategy. When you, as whether you're defense counsel or plaintiff's counsel, send out those broad, all-encompassing discovery requests, you're going to get hammered with a ton of data. And it's going to be very difficult to budget or keep control of that information because you've asked such large, broad-based things. You're also going to get a lot of expenses involved between the lawyers of fighting back and forth. And I think I'll let Matt and Sarah E. comment on the communication, which is also very key. Matt, what are your thoughts?
Yeah, I certainly would agree with that. I mean, we promote taking that kind of investigative analytical approach at this point. And one thing we're going to talk about is how that, in one of the next steps, is how that's communicated among the team. But it's real important at that front end to be be as specific as possible when we're talking about trying to find that information. And so, what we try to do is get our folks from a technological standpoint to understand the true bare bones merits of the case, and based off of that, we can start piecing together. Well, here are the puzzle pieces that will end up getting you to that closing argument standpoint, and where we can find it. And some of it is going to be, just plain old documents that people are working with, but it allows us to be more creative about trying to identify those types of information that are going to be relevant in a case. And it allows you to ask questions not only about, is it just that document, or is it earlier iterations of the document? I mean, do we care about, if we're talking about an IP case, I mean, just hearing an IP case, for those that work in the eDiscovery area, we start thinking about, well, when was this intellectual property first created? How is it we can trace the disclosure of this information? Who was it shared with? Who is it that went to the kind of joint contribution of that? And those are pieces from a legal strategy standpoint that really impact what we'd be looking for from an electronic discovery standpoint as well.
I think that one of the pieces that I also see as well is that people don't necessarily think of the approach that you're taking in terms of, if you're coming into a case and you know exactly what you're looking for, that's great. You can go straight into finding those documents and using some of the, technical features in different applications to be able to find those documents. But what if you don't know what you're looking for? What do you do then, right? You definitely have to do a little bit of an investigation to do some interviews and try to understand a little bit more about the case and where you should go and start focusing on first. What I see the most, though, is when you have all the data, you put it into a review platform, and you let a bunch of contract attorneys go through it and start giving you some information so that then you can develop your facts. What's hard about that is that it really takes a lot of time to get to even your very first list of facts. And so that's really where you need to sit back and strategize. There are a lot of different tools out there that provides you with an analytical approach to give you a bird's eye view of the documents. And you really get to select where you want to focus on first. And then obviously, what are the main pieces that you want to start looking at first? If it's a particular person, or if it's a particular communication that's between a couple of parties, or maybe even just doing a sampling of the data, trying to see what's out there. So I think that the communication internally, but also communication on what approach you're taking, and then what tools is going to get you there a lot faster.
Yeah, and just from a practical example perspective, just last week I had a matter for a client where in-house counsel called, and they had a situation that they wanted to understand what the communications had been between them and the other side, because there's a potential of a litigation situation. And so, we took some information from their email systems, and, just a small amount of information, or so you would think, just a year's worth of communication from two individuals with the targeted focus of communications just to the other side. But because of the systems that we were pulling the information from, we ended up with almost, close to 30 gigabytes of information, just email from two individuals with attachments for a year. And we had to find out whether there was one or two single emails in that 30 gigabytes of data that essentially would create more of a litigious situation for the client. And so, by using some of the things we're going to talk about here, but really the strategy was a conversation with me with in-house counsel of, what are we really concerned about? What's the legal theory that we're really concerned about? What are we concerned that our guys said? Who are we concerned about that said it? Who would he have said it to? What are some of the domains that we would have communicated with? When you have these conversations, and I'm talking about applying this litigation strategy to discovery, it's about understanding how you would look in the data to narrow it down. And I would really have to second what Sarah E. said about, putting a bunch of data in a review tool and letting lawyers go at it. There's not only the cost of putting it in the review tool there to consider, but there's also the notion that then you have a number of lawyers looking at information, and how are you going to really cull the processes that are happening in all of their individual brains into something that you can use effectively? Really what's going to happen is they're going to tag documents, and then you're going to have to go in, or somebody's going to have to go in and apply some thought to what they found. So I think if you can really have somebody thinking about these issues, you're a lawyer, or you're, great paralegal, whoever that person is on your team that we're going to talk about next, that's going to be really, really important to the ability to narrow what I call what goes into the funnel. So I think of discovery for any matter as a funnel. The less information you put into the funnel, the less it's going to come out, and the more you can filter it as it goes down through the funnel, the better off you are from a cost standpoint. So that's one example of how we use litigation strategy. What we did is, with those 30 gigabytes of data, is after about 10 hours of time, I think we spent very little amount of money, just a few $1,000s, and we got it down to less than 300 emails that needed to be looked at. And even then, we could cull it down to 5 or 10 that counsel really wanted to review to be able to see whether that language was what was going to be problematic for the client. So there are different tools to be able to use for that, but it really is the thought process of that conversation and asking the right questions in that conversation. My experience is that asking those questions and having that conversation with the right person is where we're missing things in electronic discovery. So I would encourage you within your organizations to force those conversations, have them. And I think that's going to make a huge difference for you. Let's move into number 3 on our list, which is case knowledge for all team members is absolutely critical. And with that, I'm going to set up the second poll question for our participants to answer. Let me just...
And while you do that, I'd like to, really talk about this topic, Kelly, because I think it's super important that we don't normally talk about. Whether you are an attorney, a paralegal, a partner, and guiding your team through a case, or you just helping from a technical perspective or project managing it, it's super important for everyone in the case team to really be part of the initial conversations as you're trying to come up with the facts of the case, as you're trying to identify it and having those discussions with your client, or you're starting those interviews. It's super important for everyone in the team to understand what's happening, what still needs to be identified in the case, and then what ideas do you have on that particular case. So you also have multiple different types of teams. Depending on the case that you're working with, this is a good example where you have a partner, you have a few associates, and mainly you see that in large firms, where you also have a paralegal who's managing the case, and then you have your technical backup, which is your litigation support. It's one of those things where in a traditional case, really the information comes from the partner who's really having those conversations with the client. But the associates are the ones that are making critical decisions about how do you go about finding that information in the data that you have. And then, of course, you also have the main person who's managing the case as a paralegal, who's extremely important to know all the events of it. And then, of course, having a technical person who can really help you on how to find the data a lot faster. So if you kind of understand the roles of everyone, you really have to sit back and think about, if I provide this information that I'm still even finding those facts, it gives you a good overview of who needs to be involved in that. If you kind of go a couple of slides over, there's also different types of teams that you can also think about, right? So this is obviously a traditional one. If you go to the next slide, Kelly, you'll be able to see that. So there are sometimes in smaller cases or even where you enlist an outside provider that can help you throughout the entire process. Or you also have your internal technical team, litigation support team, who's helping you with this outside provider. So it doesn't necessarily matter how the teams are put together. Really what matters is understanding everyone's roles and understanding what information you need to get from this particular case, right? And so if you start sort of looking at some of the major topics that must be discussed, is what are the facts? So what are the facts that we need to get out of this case? A technical person or an outside provider will be able to give you all kinds of different technical ways to get around it, to go and find the data. And kind of going back to the strategic point of view that we were talking about before, it's don't go at it blind, right? Get some professionals involved, tell them exactly what you're looking for, tell them what you want to find, and they'll be able to help you from a technical perspective to do some investigative approach, to go and find really those documents that you're looking for, or also understand what your discovery plan is. Understanding your schedule, understanding your deadlines, understanding what you need to do next. I'll give you an example. When I was at the law firm, one of the things that we struggle with in a case is that we had a case that needed to be prepared for depositions, and we had a massive amount of documents. And to get to it, was pretty challenging. And so one of the things that we decided to do is to use technology to get to those documents a lot faster. The case team was not familiar with it, and there was a lot of hesitation all around. But what we did is we used technology to go and to train the system, as technologists is to review, to train the system to really go and find only those documents that we were looking for so that we can prepare for deposition. It didn't necessarily mean that that's the technology we were going to use for the entire case. We used it only strategically for that particular event that we needed to get to. So back to the communication piece and getting everyone in the same page, this was something that that was a discussion between all of the teams to really understand, how do we go about it? How do we go and find what we need and also meet our deadlines? Same thing goes for, as facts change along the way, everyone needs to know about them. Specifically, if you're using keyword terms and those are constantly changing, there's specific key custodians that you came about. Maybe we're readjusting the date, the date of the documents that you're really looking for. So facts change, or facts really start coming in as the review goes on, and sometimes you have to take a different approach in the middle of your case or as you're reviewing your documents. So definitely communication with the team is extremely important. I would also say that you can also use other types of technology to make sure that everyone is involved. Specifically, if you have people in other offices, or you're using contract reviewers, or whoever's managing that team of reviewers, you can use video conferencing. There's a lot of technology that we can now easily get to make sure that everyone is on the same page.
Just to add to some of this, and I can't emphasize enough the importance of this slide and the communication with the team. One of the earlier slides showed, and I don't think it was intended to show linear approach, but it shows a little bit more traditional linear approach to the process. And we've all been in this process where communication goes from partner to associate to paralegal, paralegal to litigation support, and so often there's not kind of an intertwining of communication back up the chain or across the chain. In this last slide that Sara was talking about, I think it's so important to understand that each of these people, it's not as though anybody is a subordinate. It's that everybody is a subject matter expert that brings something incredibly important to the table, and there needs to be that interplay between the lead attorneys on the case and everyone that exists on the case. I'll give just a couple of examples. I know Sara mentioned on the custodians, an example of how this would end up working. Oftentimes, we will get a list of key custodians from legal counsel that we're working with. What I see as one of our jobs is to look at the mass of data that we may have collected and give reports that tell us what users are in the email chains. And the reason we do that is because if let's say it's a white collar type case where we're concerned about communication outside of the company, and we see that an individual is communicating with somebody outside the company, well, if in our reports we also identify the fact that there's a high percentage of communication where another individual has been copied on those messages, we may want to bring them into the loop as a key custodian on this case, and to start looking at them more closely, and to start looking at the information they have. And the only way that's going to happen is with a balance of communication between those who are doing the work and those who are managing the case. That we often see that come up with search terms as well. For those attorneys and paralegals that are on this, when you ask a service provider to run search terms, if what you get back is the result of those search terms and that's all, I would suggest you should look further for another service provider, because what you should be getting back is an analysis that tells you, how effective are these terms? I mean, are we getting false positives, and are there ways that we can structure those terms in a more efficient way to get the type of results that you want to be looking for? So And that only is going to happen when you have this kind of intermingling of communication. Those of us who work in this area exclusively, talk about this iterative approach, testing and sampling, continually testing and sampling, going back to the bucket with the information that we've learned to refine how it is that we're going to move forward. And I think that's extremely important in this section when we talk about communicating with the team.
And the other thing to that as well is that, when you start your case, most people really want to go back to what worked before, right? I had a case and we did 1, 2, 3, and so we should do the same thing on this next case. And so I would say that just like what we've mentioned before, not all data is created equal, not all cases are created equal either. And so one thing that you definitely have to be able to ask the entire team is, how is this case different? And what do we know about this case that it's a little bit different than what we knew at this time around for the last case that we did? And how do we go about it, right? And so rather than going at it blind, you start really putting, not just communicating with the team, but also putting a strategy in place right up front. Just like what you've mentioned, right? And if you are going to be used in search terms, it's completely fine. And you can certainly go about it in knowing exactly what you're looking for. But I would also bring in your outside provider or your litigation support members, because they'll be able to provide you with some techniques where you might be able to know exactly what you're looking for, and they might be able to give you technology or different tools that are out there that would be able to easily go and find the same similar documents across the case, or really save you a lot of time in having to do the fact finding with the data. So definitely, I think sometimes we think about bringing the technical folks right later on once we know a little bit more about the case, but really at the end of the day, that's when you want to bring them in earlier so that they can help you get there.
And I'm going to add a completely different perspective, and I didn't really mention it at the outset of our presentation today, and I should have. One of the reasons that I asked both Matt and Sari to join me today was because we really have 3 different perspectives for you. Matt is also an attorney, but his time is spent more on the digital forensic side and on the consulting side as it relates to electronic discovery now, although he's an experienced litigator and can bring the same value to the table. I'm working more in the attorney role, where, on this kind of list here where you've got lawyers, paralegals, lit support, and outside providers, I'm the lawyer who's advising the other lawyers on the team why what we're doing is the most effective discovery approach. And from my perspective, the things that I want my team to understand are where we are with the case. It's all the pieces that Matt and Sarah E. have been talking about relative to what are the actual pieces of information you need to know to do your jobs effectively on the side of handling the data, the custodians, the date range, what we're really looking for. But there are bigger pieces too that are sometimes larger considerations, and those are, what's the scheduling order in this case? What are we planning to do before we've even got an ESI protocol negotiated with the other side? How likely do we think this case will go away on a motion to dismiss? If I'm the defense and my client feels as though there's a 90% chance of success on a motion to dismiss, then the amount of effort I'm going to expend prior to that ruling is going to be different. And, I've got a case right now where counsel advised us specifically that the judge is not amenable generally to putting discovery on hold while a motion to dismiss is pending. So that changes the variables. So, there are big considerations from a scheduling order perspective, from a motion to dismiss. What does your timing look like? There are also significant PR considerations sometimes in how things are going to be handled. Whether you're going to use contract review people, what are the sensitivities for the client? What types of other PR issues might exist within the data that you're collecting? As targeted as we want to make collections, there are always going to be those issues. What kind of process does this client have for identifying potential recipients or creators of privileged information? All of those kinds of things are very important to communicate with the team. And I usually sit down at the outset of my matters with processes for a particular client and make sure that the team is familiar with them, even if we've done them 5 times in the last 3 months, so that everybody's on the same page, and that processes are written up for clients for particular matters that can be followed in case somebody has to step in. I mean, that happens a lot, right? Something comes up, some data comes in that has to be dealt with quickly, and that particular project manager or lit support person or paralegal or lawyer is out. They're in trial, or they're involved in something else, or they're just on vacation, or they're out sick. And you've got to be able to pick that up and run with it. And if you've got to find processes and an understanding of what's happening with the case that's updated regularly, in terms of team communication, that's going to significantly benefit what happens with the client. And then I think we're not going to talk about it here, but in large part, what I view as being important is providing that reporting to the client later. So as a case wrap-up, which I don't think happens a lot when it comes to discovery, we tend to just stop when things stop, is to provide a case wrap-up of what's happened. Okay, let's move on a little bit to our fourth important point when you want to be able to conduct a discovery efficiently and effectively, and that is really to understanding cost structure when it comes to eDiscovery. And with that, we're going to do our last poll question for today, which is, whoops, not that. What is the average value of the matters that you're handling? So as that's going on, Matt, do you want to jump into talking about costs and cost structure within electronic discovery and what you find most effectively in trying to manage it?
Sure. And I would say, the first thing we need to recognize is that this is a part of the process that it does cost money. You can't do it for free. And there's, as I think Kelly mentioned earlier, I mean, there's always consequences for whatever path you decide to take. I think the path of ignoring eDiscovery is probably the worst choice, but that's because I'm in the business, I'm sure. So I think a few points. This issue of being thoughtful about preservation scope. What we mean by that is once we've identified the sources of information that we talked about in the first section, we need to think about how much data we're going to collect or preserve at that point. Kelly talks about the funnel and how information kind of flows through the process. From our standpoint, we try to preserve broadly because it ensures that we don't have to go back to that source of information again. But I'll tell you, it depends on the nature of the case. We have had some cases where the quantity of information to be preserved was so large that it made more sense for us to do an analysis of that information on the front end and do a selective preservation. So, changing how it is you preserve information on the front end can, certainly save some significant costs. The other thing that is real helpful for minimizing costs is this concept of early case assessment. And as the three of us were talking ahead of time about this, I mean, we hear about this ECA or early case assessment being used in the context of tools, and people want you to run a tool for early case assessment. And what I would say, and I think we all agree, is that it really is a process. I mean, the tool can help us digest the information that's there, but you really need a subject matter expert to look at that information and make some decisions about what you want to do moving forward. In your cases, you should have an expectation, if you're working with an outside person, that you get a report on the front end that tells you what the breakdown is of email and user documents and encrypted files and files that are not text searchable that might need to be OCR'd before they can be searched, and files that, let's say it's an engineering claim, you might have CAD drawings that exist in there. I mean, you want to see that so that it gives you some context of how you're going to review it. You may look at that list and you may have thought initially that you're going to apply 100 keywords to identify documents. And it may be that in looking at that kind of report, it will tell you all you need to do is to go into John Smith's folder, into his project folder, and you've got 90% of the documents that you need for the case that you have. And so early case assessment really is that process of trying to look for efficiencies by looking at the macro level of the data, the top level of the data. So often we're trained as attorneys that we have to put eyes on every document, and that's the way in which we determine whether or not something is in the bucket or out of the bucket. And what I would say is, in the eDiscovery world, that's not the best approach. It's not the most efficient approach. And I'm not suggesting that we toss out all of the stuff that doesn't make the first cut. It's just that, again, we use an iterative approach. We find what information is the lowest hanging fruit initially, and then we go back and try to find more. As far as collection methods, this kind of goes to the preservation, but there's lots of ways that information can be collected from remote machines. That's being done more often, especially with information existing in the cloud. In some ways, it makes it easier for us to grab custodial information, and that does help reduce some of the costs.
And Matt, I would add to this, going back to our communication item, is that really this is where you want to get if you're defending your client, this is where you want to get their IT folks to talk to your either service provider or your litigation support person, because that's really where the main communication breakdown happens. When you are trying to be very methodical and trying to do a targeted approach, but the IT person at the corporation is just basically grabbing an entire chunk of the data that they think that you may need, and they give you more than really what you're looking for. And so having those two technical people talk up front, it really makes a huge difference. I'll give you an example. We've had a matter that we were helping with recently where the collection of the data was the entire document management system. And when you really look at the type of case it was and how much it was worth, it really didn't make sense for us to help through getting the data completely processed. It really needed to be that IT person who had access to get the data out to do more of a targeted approach rather than getting the entire system collected.
Yeah, and I agree completely on that. I mean, I think that's one thing when we were talking earlier about the team, the role of the client in that team and the internal client resources is so critical. The IT people, and to your point, I mean, you need to be real careful because we have had situations where in the early days of electronic discovery where a litigation hold would be put into place. And what would happen is that the legal department would direct IT and say a litigation hold is in place. We can no longer delete any information related to these clients. And without giving any context to what the case is and what we're really trying to do. And what happens is then that continues for 6 months or 8 months or a year. And now we've amassed an incredible amount of information that we need to deal with without being more strategic about how we carry out a litigation hold. And so I agree that communicating with internal IT is very, very important, but also communicating in a method that's respectful of their knowledge and what it is that they know how to do. They're going to interpret some of these things differently than how we talk about it on a daily basis. And I think that just needs to be made really clear so that we can benefit from the resource that they bring to the table.
And I'm going to chime in a little bit because a lot of times what's going on in my brain as a case comes up and I'm on the phone with a client about a case, I'm thinking, as they're telling me about the case, I'm thinking about the date range, the custodians, the volume of information I know we normally have per custodian for this client, how much information we're going to have, what types of information it is. We had on an earlier slide the data equality notion where you're looking at, a gigabyte of email is not the same thing as a gigabyte of marketing materials, because you're going to have a lot less files, a lot less text, a lot less information to deal with. And so in my brain, when I'm thinking about what a new case is, I'm automatically running through a cycle in my head of what's going to be the best process for utilizing tools here, what's going to be the best way we're going to need to look at this case, what's the value of the case, how are we going to handle that process. And it's that piece that I think a lot of you on the call today have the ability to provide that input for your client. These are the ways in which we can structure this, because it's different than other cases. Like Sarah E. mentioned, there's no one size fits all. And how can we best do this economically? And I think that understanding what costs are involved in different types of processes and tools will really help you to be able to make some of those decisions better. So if that's not an area where you have a fundamental knowledge right now of what you're using and costs and how to decrease those costs, it would be well worth for your clients and your organizations to get a better understanding there. Let's move. I'm going to just move, if I can, Matt, because we've got about 15 minutes left to number 5, and then you can add what comments you have as we're going. Go ahead.
Just one last comment on this, and it kind of ties into communication and minimizing costs as we go into number 5, and that is, don't forget about the communication with opposing counsel. And I'll say we've seen an opportunity for drastically reducing costs by being more open about this eDiscovery process with opposing counsel and making decisions about those things that will be preserved, those things that will be processed, and those things that won't. And that can be very helpful.
Somebody just asked whether we'll be providing the slides to everybody after the call, and we will be sending those out to everyone. So those will all go out to you, and you're welcome to share them. They'll also be available on SlideShare, and we'll be posting the recording of the webinar as well for you to be able to share with colleagues. Let's move to number 5. Oh, and let me remind everybody now that I'm trying to save some time here at the end for us to be able to answer some questions. So if you've got questions, please feel free to put them in the question queue, and we'll get to them in just a couple of minutes. Our last major point is identifying tools for use with any size matter. When we sat down to think about, the best points to talk to you about today, tools are always a hard discussion topic, because everybody wants to say, what should I use for my case? And any one of the 3 of us would look at you and say, okay, well, I have a lot of questions about your case before I could tell you what the answer to that question would be. And that's not typically what everybody wants. Everybody wants an answer. What should I use for review? What should I use for this? What should I use for that? And it really is dependent on a number of issues. And so I think that, different tools are built for different reasons. And one of the things that we'll show on the next slide is that you need to understand the limitations of the tool that you're looking at. So when you're thinking about tool selection, and these factors vary kind of depending on the tool that you're talking about, whether it's a review tool, a collection tool, an ECA tool, what are you really trying to do? What kind of data are you looking at? What kinds of filtering are you trying to do on a regular basis? What are the needs of the client that you have? How many cases are you looking at, and how much data are you looking at? What kinds of data are you looking at? What are your internal resources to be able to manage that process? And what do you not have? Do you need to outsource project management, your typical litigation support functions, to a provider, and be able to partner with a provider not only to maybe collect and manage the data for you, but also to help you project manage it, set up the database, understand how to get the most value out of the tool. So what are those needs? When my firm looks at purchasing tools, we immediately look at what are the client needs that we're trying to meet. We recently had a client who wanted to try and limit collection costs. We do as much filtering as we can possibly do using ECA and some of the other methods that we've talked about today. But we wanted to try and eliminate collection costs because that was one place that, as I looked at the numbers, we were spending more money than I thought we needed to spend. So we started looking at remote collection tools, and we needed to understand where information services for that client was going to be going. Right now, they operate with an email archive and some other pieces with Microsoft Exchange, but they want to move to a different environment. And so how does moving to that different environment affect what tool we might use for remote collection? I'm a big proponent of leveraging the cloud. And so, I typically look to those services, but there are lots of considerations in working with information technology at a client on how to make that happen. What's your relationship with the client? Can you work directly with information technology at the client to implement these tools? Because they typically aren't things that you can do on your own with corporate clients that are locked down. Smaller companies or firms that don't have such a lockdown IT system will be a little bit easier to implement tools with, but there are a lot of considerations and a lot of setup time to try and deal with them. So, it's important to think about cost, budget, and realizing that not one size fits all. Sorry, Matt, what do you guys have on this?
Well, one thing that I would say to this is that, there are many different cost-effective tools, whether your matter is pretty large or your matter is very small that you don't necessarily have the budget. I would say that even if your matter is large, there are so many tools out there that may look like they cost a lot up front, but you'll be able to save so much more money based on using some of those techniques, like analytics, like Matt was saying. Being able to use analytics to easily go and find the most relevant documents from that the other side just produced to you is huge. It saves a lot of time. But I'll give you the smaller cases. I still see firms reviewing documents in their shared drive or a location that doesn't even have some sort of database tool. And there are many review tools out there that will be able to easily help you get through the data, search for it, tag it, produce it. At iPro, Eclipse SC, it's one of the small factory type of tools that we use a lot, and it costs basically $750 a year. It's crazy when you start looking at the cost and how much it actually can save you so much time. One thing that I would say is Outlook is not an eDiscovery review tool. That's one of the things that I see a lot and people wanting to just take a quick peek at some of the emails that were just sent to you by the client. And there are so many things that could go wrong with just opening that type of evidence in Outlook. You're not able to search it correctly. You may be missing a lot of information. As most people like to drag and drop to different folders. You're not able to search for those documents like Matt was saying that require OCR. And then of course documents get moved around to the deleted items. There is an archive system that may have been in place, et cetera, et cetera. And so, but there are other tools that you could be using even for the smaller matters where you just need to scan some documents, put them in a PDF format. As you can kind of see, we basically just put a few of them in here that cost very little, or even there are some free tools out there. Even when you go to trial, there's a trial pad where costs very, very little money for you to be able to create a presentation right up front. So at the end of the day, it really goes back to our earlier point, how much does this matter cost and what is your budget look like? And even based on that, what is the most effective tool to save me more time so that I can then focus on finding the key documents and also being able to work on multiple cases than just one where you have to spend that much time in finding documents.
Yeah, I would say, we listed some of these tools here because that is so often a question that I get, is what are the tools that you use to do some of the things that you talk about? And again, as Matt was mentioning earlier, there are so many different tools that may meet a need or a situation. Some of the ones that are listed here, FDK Imager is a free tool that you can download from Access Data. And as we were kind of leading up to this morning, Matt made a very good point, which is, it scares him, and frankly, I think me, to suggest to someone, hey, go on and download FTK Imager and go out and start collecting your own data if you don't know what you're doing. So, you know, to the extent you need to start being able to do some of that for your organization or your firm, you need to understand and get the right kind of training associated with that. And that training is out there and available to do. I think that there are a lot of potential problems associated with people just jumping on and starting to use some of these tools, and to thinking that it's the end-all be-all just to be able to download one and start using it. That being said, it really does require a lot of investigation into what the tools are, how they're going to be used, what your level of expertise needs to be able to use them, and how you're going to use them. For some of the ones that are listed here, for those of you who may not be familiar with them, you know, within collection, I just talked about FTK Imager, Harvester, and eCapture are both remote collection tools. Within ECA, I think, Matt, you use the Proof Finder and Intella, don't you?
Those are some of the tools. I mean, that's a challenge with this topic, is that in-house, I mean, we use hundreds of tools, and it really depends on the type of information we're trying to get into. And I'll give you I don't know if you want to walk through each of these, Kelly. I was just going to give another example of where these tools in-house can be really useful. We are increasingly finding cases where we'll have unusual types of data that do need to be reviewed. I mean, they might be database files that are pulled out or things like that. And CAD drawings is another good example where somebody to look at those and to actually look at the layers of files that exist. There's different kind of individual review tools that may be better than putting them into the general review population. And I think in those situations, you definitely find some cost savings by assigning somebody to review those, bring those in-house. My comment earlier about the warning on these things is that in our eDiscovery world, we run this fine line between processing or handling data just for the normal discovery process and handling it in a way that creates evidentiary trails or potential expert kind of opinions as to what the data means. And I think that's where we just need to be careful when we're doing some of the stuff in-house, to really know what these tools are doing as you handle data.
Or also look for service providers that have the ability to give you a platform of solutions.
Yes.
You know, iPro, has a lot of different service providers and partners that we have provided that kind of platform that provides, you know, a streaming mechanism that provides a little bit of different points where in every case you'll be able to use it and save a lot of time, as well as, you know, making it even more efficient.
Guys, we just have another minute or so here before the top of the hour, and I want to come back to a couple of questions that have been raised. But in the meantime, I wanted to be able to say thank you very much to iPro for sponsoring our webinar today, and let you know that iPro has set up a discount for participants to be able to receive a discount on Eclipse SE, which is the desktop version of the review software from iPro, which is regularly a $750 license. They're providing a 10% off discount. You can visit that link that's there and enter the code that's there to be able to get that discount. If anybody has any problems, you can absolutely email me and we'll get in touch to be able to handle it. In addition, one of the things that I have done apart from ESI Attorneys is to create a platform called eDiscovery Assistant, which is a virtual online consultant that will be available at the end of the month. And so I'll be emailing participants about a free month trial to be able to try out eDiscovery Assistant. So we'll be in touch about both of those things. If you have any questions or whatever, you're welcome to reach out and contact me associated with those. I want to go back a little bit to the questions that we have here, and if you're able to stay on for a couple of minutes and just be able to answer them. One of them, sorry, you already answered. Somebody specifically said, I have a lot of people in my firm who are using Outlook to be able to look at information that I'm sending them from our review tool. And it's frustrating. How do I get them to stop? How do I explain to them that that's not a viable solution? Matt, you have any more input there?
Well, I mean, there's several aspects. I mean, one is when you're using Outlook to look at the PST files, you're actually manipulating data within the PST files. And so there may be some of that metadata that's extremely relevant to the type of case that you have. An example would be in a lot of white-collar cases, knowledge is an important aspect. And so if somebody had received the message, but they had not actually opened the message, the fact that they had opened or not opened the message may have some relevance. So that would be an example. The other thing is, from a searching standpoint, depending on what the attachments are that are on the documents, Outlook's search mechanism is not designed to get into those files the way a normal eDiscovery tool would. And you can't build any complex searches to build search phrases within that. And so it can be a real challenging item to use to try to do actual eDiscovery with.
And not only that, you're altering the evidence of it. I mean, you open a document that changes the last person that modified it. It also could send some read receipts. You're changing whether it was a read email or not. And so it's extremely critical to make sure that if you are wanting to use a low cost type of tool, that you look at some of the options out there that might even be free options or very low cost type of review tools. So definitely know the limitations of the software that you're using.
I was trying to pop back to the list that we had here. Yeah, I think that when it comes to Outlook, I've actually had a situation recently where we had opposing counsel that wanted to produce information to us based on searches that they'd run in Outlook. And we challenged them on whether or not that was a reasonable step to take to be able to meet their duties in producing information. And we haven't resolved it yet, but we're continuously trying to educate them. And I think that education theme is one that we haven't verbally stated as much today, but I think that there is a constant source of education that has to happen all the way up the chain in order for electronic discovery to be conducted effectively across the V, within your own teams and organizations, and to be able to communicate effectively, because most of the time within law firms, we don't know what we don't know. And in large part, it's incumbent upon the litigation support professionals and the paralegals to start helping to educate the attorneys on how you can help them, on what the things are that they need to be thinking about. We see it in our audience today, which is largely made up of litigation support professionals and consultants and other folks who are not attorneys. And we need those attorneys to understand what it is that's not happening in the eDiscovery process. And it really is going to be incumbent upon all of you to continue that education up the chain, down the chain, however it needs to happen. It's a process that I have to engage in every single day with my clients. I can be on the phone with a client who I've done 10 cases for this year, and they're asking me a question that I just have to keep answering in the same education manner that we've done previously 10 times, because it isn't their focus. It isn't what they do on a regular basis. So with that, we're going to kind of wrap things up today. If you have other questions to submit, please feel free to drop me an email. All of our emails are, again, here at the end of the presentation. Please go on and take advantage of the opportunity to be able to use the Eclipse SE. That is a tool that we use internally here at ESI, and it's a good one. Again, we'll be in touch about eDiscovery Assistant, and we very much thank you for your participation today. We welcome all feedback. I'll be sending out a survey, so if you could take a couple of minutes and just give us some input on what the content you found to be valuable today and additional topics that you'd like to see covered. We'll be doing more webinars in the next few months and reaching out to try and figure out topics that are of most interest to our audience. So thank you so much. Have a great day and enjoy the rest of your week.
Thank you, Kelly.
Thanks very much.